Thank you all for coming. It looks like last night might have been a really good party, and so attendance may be a little low. We might. I'm told that we might have some stragglers coming in on the way, so we'll see how that goes. But and I apologize for this, but I'm going to move this around so that I can move this out of the way and get my paper here. All right. Well. That's not good. Apparently I just moved it too much. So today's speech is going to be 7 legal pitfalls. 7 legal pitfalls that affiliate marketers should avoid. And the idea behind this presentation was that we seem to see these 7 issues arise over and over with businesses in this industry. And these are easy things with information to avoid, but after the fact are a little bit more complicated to try and unwind or protect yourself. So hopefully when you walk out today, you'll feel a little bit more informed on some things that maybe for your business you could do to easily reduce your business risks as you go forward in this industry. So we'll start with the first one, which is entity formation. And we start off with some defaults because a lot of times people in this industry maybe will start by buying a domain name, buying a couple domain names, start operating, doing just a little bit. Maybe they're not sure if they're going to stay in it. Maybe they don't have a lot of experience in it. Maybe they came here for, to get some information. And as they operate, they start populating their site. They start making some money on their site. They might start doing business as, affiliates are us, whatever the name of the company is. But because they're not sure if they're going to stay in the business, they don't want to spend the money to form an entity. Well, what that does is that means even if you start saying that you're, affiliates are us, you're a sole proprietorship, or maybe you're working with another person, and one of you buys the domain name personally with your name, and you're operating as, again, affiliates are us, and it's you and your friend. Well, at that point, you're a general partnership, and that means that each of you has 100% personal liability. You may have claims against each other in the event of liability, but you have full personal liability. So what are your options? Partnership, I just mentioned it. It is a form of formation that you can choose. You also can choose corporation. There's 2 types of those. There's a C corporation and an S corporation. Or there's a LLC, a limited liability company. So what are the benefits of forming this entity? Because as we've talked about, there is a cost associated with that. Now there's a variety of different ways that you can choose. You can hire a lawyer, you could go to LegalZoom. There's a variety of different ways that you can form an entity, and it sort of depends on what your needs are and whether it's just you. Is it more than just you? Are you going to be bringing in capital from third parties who are going to invest in you? All of these are issues that would need to be investigated when you're making the determination of whether or not to form an entity, and if so, what type of an entity should you form. So why would you form an entity? Well, we talked about personal liability, and asset protection goes into that as well. What does that mean? It means that if you have if you, let's say, infringe on somebody, God forbid anybody in this industry would ever infringe on anybody, right? If you have personal liability, what's at risk? Well, your assets are at risk, your house, car, 401k. You also have, even if you say, well, I don't have much money, they can't really get anything from me, and that might be true, but they also can have personal liability where they can get a judgment against you, and then over time, when you do make money, they can execute against you that way. So many of these entities that we're going to talk about give you limited personal liability, where the only thing that, if you're operating under this entity, what the creditors, what the third parties can go after are the assets of the entity, not you personally. Another benefit of forming an entity is some favorable tax treatment. If you have an LLC or if you have an S corporation, these are pass-through entities where you can gain favorable tax treatment, you can write off expenses and things like that. Another issue that I brought up is you can have, you may want to raise some capital for your idea, whether that's family or whether that's outside investors. And some entities are easier than other entities to raise capital and transfer ownership. And so because of that, you might preemptively try to form an entity that gives you that availability and ease. So determining the right business, the right entity, you want to look at all of these different issues. We talked about the limited liability. One of the things, if you put, say, $20,000 into your LLC and you operate this business as a separate entity, you're not, buying personal groceries and things like that, but you want to keep it as a separate entity. By doing that, all that's at risk is the value of the entity, the amount that you've invested, and then any assets that you acquire. You protect yourself from both creditors as well as third parties, based on any kind of claims that might be against the operation of your business. And the last issue, some people operate in riskier areas of affiliate marketing than others, and the riskier the business, the more important that it is to really isolate your risks and your liability. So, we started talking about general partnerships and sole proprietorships having unlimited liability. General partnership is if you and your best friend start operating the business. You don't have any formal documentation that creates any entity. The default is that you're a general partnership. And then the sole proprietorship is when you buy your domain and you start operating that domain based on just owning it personally. Entities with limited liability are S corporations and C corporations and LLCs. Tax implications, the C corporation still has what's called double taxation. You're taxed at the corporate level as well as on the personal level when you receive your distributions. However, an S corporation and LLC have pass-through entities, or are pass-through entities, and then an LLC, this bottom one, there's some potential self-employment taxes. I think if you do decide to form an entity, you should talk to your lawyer about it, and they can explain maybe what the benefits and drawbacks of the tax issues are. So ownership, an LLC is one or more members. Just because it's just you can still, you can do an LLC or an S corporation. S corporation has some specific limitations on types of people who can hold shares. Foreigners can't own S corporation shares, so there are some limitations. There's limitations on number, entities. There's some restrictions on what entities can and can't own S corporations. So again, if you're thinking about raising money, you want to make sure that you choose, from third-party investors, you want to make sure that you choose an entity that works for your needs. And then transferability, and this is an issue that you should think about because transferability, sometimes ease of transferability isn't a good thing. So you want to make sure, do you want, say, somebody who owns stock or a membership interest in your LLC or your corporation, do you want them to have the ability to sell it to somebody you don't know, somebody who maybe you don't want to work with? So transferability is a big issue, at least to explore when you're thinking about forming your entity. So what's the bottom line of entity formation? First of all, I would recommend that you all, if you don't have an entity, you think about forming an entity to do whatever it is that you do. There are some upfront costs, but you will protect yourselves, your limited liability, and you also can gain some tax benefits. Now lastly, for all of you who happen to have an entity and don't think that this applies to you, if your business does a variety of different things, if you operate in several different areas in this space, it would be a good idea for you to think about having multiple entities. That if you run, let's say, a website that sells widgets, and then you also run a blog that has lots of third-party content and advertising, it would be a good idea to at least investigate whether you should have those operated under separate entities, and therefore creditors or third-party claims against one or the other would not put at risk any of the assets that you hold in the other entity. Okay. The next pitfall is analyzing affiliate contracts. So a lot of times people either don't pay attention to the contracts that they're signing or accepting in, say, a dialog box in this space, and this is a dramatic statement: never work with an advertiser or affiliate program without a contract. It's really a good idea to know what terms you're agreeing to. Don't just click through and accept terms, and if there are terms, make sure that you understand what they are and that they're not overly one-sided to the point that it could cause you problems down the road. An advertiser or an affiliate program almost always has a standard affiliate contract. That doesn't necessarily mean that you've read it. It doesn't mean that you realize that you've agreed to it, but you really should look into it, and you should make sure that you're informed on what those terms are. All right. So what should you pay attention to? Most of you all will pay attention to how you get paid, right? You're going to know whether it's on a per click or a per lead basis or per action. You're going to pay attention to that. Everybody wants to pay attention to how they're going to get paid. But is there lead volume in the contract or in the insertion order? Has the advertiser limited it? If they have, are they going to pay you for whatever volume goes over? Are you allowed to transfer that traffic once you've hit that weekly or daily limit? Some contracts will tell you that you're not, that although they're only paying you for 1,000 leads, that you're not allowed to transfer, that they own that traffic, you're not allowed to transfer that, so you potentially could not get paid for volume that you send to that advertiser. Is there a step up in the commission? If so, is it reasonable? Do you really think you can get to that second tier? If not, is that lower tier adequate to compensate you? Are there termination provisions? Oftentimes, termination provisions might say that if they terminate you for breach, they don't have to pay you for any of the commissions that accrued prior to the termination, regardless if they had anything to do with the breach. So that could potentially be a lot of money that, in the end, you have no right to demand. How much notice do they have to give you before they can terminate? So you should also know what qualifies as an action or a lead, what's required if partial information is filled in, or what information is required, what are they asking for, what's the time frame that they have to protest or that you have to protest if they claim fraud or that a lead isn't a lead. Is there a limitation of liability provision in the contract? And what does that mean? Limitation of liability can say that one party or both parties can have a cap on liability for some amount. Might be $500,000, might be $50,000, might be $1 million. But you should know what that limitation of liability is, and is it something that you feel you aren't going to be out a lot of money if there is a claim based under the contract? Is it mutual? What does that mean? That means, does it just protect the advertiser and not you? You want it to be mutual. If there is a limitation of liability, you want to have the benefit of it as well as the advertiser. And are there consequential damages disclaimed? What does that mean? That's a big issue, because consequential damages means if you breach something and it causes damage to somebody else, can you get sued for all the things that occur as a result of what you did in violation of these terms? Consequential damages can add up quickly. It can be a lot of money. And if there's no limitation of liability, it can be you can be at risk for a lot of money. Are there indemnity obligations? Are you indemnifying them for third-party claims if they get sued for something that you did? Are you indemnifying them for that third-party suit? If so, again, is there a limitation of liability? All those kinds of good things. So you should read your affiliate contract, make sure you understand it, and then once you have and you're informed, then make sure that your website or whatever your area of expertise is, make sure you follow the terms. There might be some very simple things that you can do to avoid liability just by knowing what's in these terms of service, or at this point it's a contract. You might be able to make some very simple adjustments to how you operate or what you do that can avoid liability. The problem is a lot of times our call is after that liability has accrued, you didn't read your contract, and you're trying to unwind something that could have easily been avoided. And that's why we believe that this is one of the pitfalls that you can avoid if you do it up front. So number 3 is terms of service. So what we just talked about is a contract that you have with an advertiser or a network, and what are those terms? This is dealing with terms of service on a website. Might be terms of service on your website, might be terms of service that you agree to through, say, an affiliate network or something like that. But what are terms of service? Well, a lot of times people don't pay attention to this either. Terms of service are essentially the contract between the user of the website and the owner of the website. So it's a contract that can have all the same sorts of issues and allocations of risk as the contract itself can have. What are some of the issues that you should pay attention to if it's you who's doing these terms of service, and it's your website, and this is how you are contracting with your users? First of all, the DMCA notice. You should make sure that you have all of the required DMCA information in your terms of service. What does that mean? And we're going to talk about DMCA later, but in your terms of service, you need to have a name and an address and an email that somebody who has a DMCA claim regarding content on your website can access. You should have a reference to your privacy policy, and we'll talk about privacy policies next. But you should incorporate your privacy policy in your terms of service. You should make sure that there are disclaimers saying that whatever service you're providing, whatever it is, that it's as is, that you're not guaranteeing that it won't be uninterrupted. You should have references to links. If you link to other third-party sites, you should disclaim both privacy policies and you're not endorsing those third-party sites. You should have a limitation of liability in your terms of service, or you should, again, make sure that you understand what the limitation of liability is with your with the website that you're entering into business with. Sure.
What about punitive damages? I mean, can we limit that? And any kind of lawsuit from a private person using our product?
Well, sure. And that, just like the consequential damage reference that I made, usually the disclaimer that you should have in, say, your terms of service or your contract, and you should make sure are in somebody else's form contract that protect you, is also a disclaimer of punitive damages. Now, depending state by state, punitive damages may or may not be available just by statute, but by expressly disclaiming punitive damages, you can protect yourself from those as well. So then the other issue at the bottom, terms governing the submission of user content. So, and this relates back to the DMCA issue, but if you have a website and you allow third parties, so other people, to post on your site, DMCA is a really important piece of the puzzle for you. You need to make sure, and it's really simple, you need to make sure that you've registered with the DMCA, or registered a DMCA notice, and that you have all the required information on there. And what that does for you is it's going to protect you from infringement or certain defamation for user content that you don't modify or edit. Yes?
Is that inclusive of comments, like comments on your blog? Do you need to be protected from that? Or if somebody is like posting on your blog?
Any third-party content that you allow somebody else to put on your website. Now, there are some specific regulations that we're going to talk about later that you need to follow in addition to just registering. But by all means, DMCA is a great asset for you if you allow third-party content on your website. You also want to make sure in terms of service that you have a choice of law, excuse me, and venue provision. What does that mean? That means that you choose the choice of law. If somebody wants to bring a claim against you, it's Nevada law. And if you're located in Nevada, you say clearly in your terms of service that if somebody wants to sue you, they have to come to Nevada and they need to sue you here. What that protects you against is being sued in Florida. You're located in Nevada, a lot of extra costs. That doesn't mean you won't get sued in Florida, but the terms of service, you can try to enforce those terms of service, make them transfer that claim to Nevada, adds cost to them, ease of litigation or easier litigation for you. It's a big bonus for you if you do get sued to have those types of provisions in your terms of service. Terms of service enforceability. So what this is talking about is you have these terms of service, you got a link at the bottom of your website, right? Well, so how do you make sure that these terms of service are more likely to be enforced against users of your website? When you're signing a contract, I send you my contract, you sign it, whether you read it or not, you're held responsible for having read it. Terms of service is a little bit different, right? Because it's at the bottom of the page. Maybe it's not easily findable, whatever. So there's a couple issues or considerations for making your terms of service more enforceable. So are they hidden? Are your terms of service hidden? Or a lot of websites will put them right at the top, right? So you don't have to scroll down to see the link to the terms of service or the privacy policy. Are they hidden or are they not? Is there are the terms visible when you register? So let's say your website, I have to register, I put in my user ID, I put in my password. When I'm doing that, is the link to the terms of service available to me? Is it visible while I'm doing that? Does the website use, let's see, so the issue here is, are you allowing somebody or requiring somebody to accept your terms? Is there a check mark? Is there a click the box? Or are you just relying that somebody saw the link and therefore read it? It's a factual determination by a court of whether or not terms of service are enforceable, and what your job is to do as much as you can to make sure that you've made somebody consent to your terms of service, okay? The more things you do, the more visible it is, the more click. Do you have this click? Do you have if you'd like to print your terms of service, press here. You know, sort of Apple's iTunes, they always say, you know, nobody ever prints it, but they can show in a court of law that they've given you that opportunity. They made it easy for you to read and review their terms of service. So the more you do, the more now, if you ask any lawyer, if you follow every single thing, you let us design your website, you'll have 0 conversions. So I recognize that. I'm not going to tell you that, you absolutely have to do every single thing, and if you don't, you're going to be in trouble. What my job is to do is to tell you what the risks are and what you should think about, and if you feel like you still can operate your business and convert how you want to convert, then these are the types of things that you should think about doing in order to increase your protection. Okay, next issue, next pitfall, privacy policies. So privacy policies are, and I'm going to go over these, are sometimes required, but you should always think about having a privacy policy even if you don't think it's required by law for you. There's no blanket federal law. A lot of people think there might be. There's no federal law that says absolutely you have to have, in all instances, if you have a website, a privacy policy. There are federal laws that will go over that if you are in certain areas, you may have to, but there isn't just a blanket law that any website that doesn't have a privacy policy absolutely has liability. Some states require privacy policies. California does, and again, we'll go over that in a minute. So you should consider, if you don't, putting a privacy policy on your website if you have a website. Or if you have a mobile app, you should think about having a privacy policy as part of the app, whether it's available once I own the app or whether I have the opportunity to review it when I install the app or any of that. Okay, so the first federal law that does require a privacy policy is the Children's Online Privacy Protection Act, COPPA. So what does COPPA address? It addresses websites that are directed at collecting information from children. Okay, so it's not necessarily directed at collecting information, but it's directed at children and it collects information. What's required? You have to post a privacy policy. You have to provide notice to parents, and this is a big one. You have to provide notice to parents and obtain verifiable parental consent. What does that usually translate to? That means that in order to have a child who's 13 or younger get a user ID, you have to collect their parent's email address. Their parent has to approve that you're going to allow them to use your website because you've collected some or any information from them. You have to allow parents to review what their kids provided and that they can delete or prohibit disclosure of their child's information. And you can't condition a child's use of a website on a bunch of information that isn't necessary and relevant to the use of the website. And then you absolutely have to maintain confidentiality of that information. Now, a lot of you are probably thinking, well, this doesn't apply to me. I don't have a website that's directed at children. So last month, the FTC passed a new interpretation of COPPA. and it'll come into effect this year in July. And the new rule does broaden the impact of COPA. So it requires websites that allow plugins or third-party advertisers that collect children's information to follow COPA, okay? So what does that mean? This is talking about your website isn't directed at children, but the advertisements that you allow on your website are specifically targeting children 13 and younger. That pulls you now under COPA, okay? Operators of plugins or third-party networks that have actual knowledge that they are collecting personal information through a child-directed website. So what does that mean? That means if you, say, buy some banner ads, you need to know if your banner ads are collecting information, okay, and they get placed on a child website, that draws you into COPA. So you need to know if, as part of a media buy, if your banner ads or if your advertising is going on child-directed websites. And lastly, if the website only targets children in a secondary manner, which means it's not a website that's directed at children, it's not, Disney, but you collect age information. If you collect, in doing so, you collect the information that somebody is 13 or younger, you have to use that information in accordance with COPA. So if you're asking age, you get somebody who signs up, they're 12 years old, you've now been drawn under COPA, you have to follow COPA with that information. So what kind of information is at issue with that? It's first and last name, physical address, phone, geolocation data is under COPA, IP address, mobile device ID. I mean, it has a widespread impact. Okay. California Online Privacy Protection Act, that's what I was telling you, that in California, if you collect information, personally identifiable information from residents of the state of California, then you fall under this even if you aren't located in California. What's required? You just have to have a conspicuous privacy policy, okay? So, again, it's always a good idea to have a privacy policy, just like it's a good idea to have terms of service. This just talks about that what the California Online Privacy Protection Act allows is both private rights of action. So if I'm a resident in California and you collect my information and you don't have a privacy policy, I can bring a claim against you individually as well as the Attorney General can. Here's an example of how this has been applied recently. So Delta Airlines had a mobile app that collected personal information but didn't have a privacy policy. This last year, fourth quarter of last year, the California Attorney General sent a non-compliance letter to Delta. Delta did nothing during the 30-day window that they had. Whoa. So California brought suit against Delta in December, and they're seeking $2,500 fines against Delta per California resident that they collected identifiable information. This, at the time that we did this presentation, there hadn't been any resolution in this matter, but you can see that's a serious amount of money. I don't know how many people Delta, how many California residents, but I bet it's not a small number. So another area where you can be required to have a privacy policy. So what we said, there's no federal law, right? Some state laws, there's a federal law if you're directed at children or related to children. You also might fall under this if your merchant or affiliate network contracts require it. PayPal has a requirement for privacy policies if you run PayPal through your website. If you run AdWords, Google requires a privacy policy. So you might be in violation of a terms of service or contract that you have with a merchant that you use if you don't have a privacy policy. This is just the example for Google AdSense and how their standard terms require a privacy policy. Websites may be required to post a privacy policy for several reasons. We just talked about that. Another issue is FTC enforcement of posted privacy policies. So I know nobody in this room would ever just copy a privacy policy and put it on their website and figure that that's acceptable and they're good because they've got a privacy policy. But some people copy privacy policies and put it on their websites without really paying attention to what it says. Well, the problem with that is it might not accurately reflect how you take data, what data you take, how you use that data. But that doesn't mean that the FTC won't enforce that privacy policy that's on your website against you. So let's say your privacy policy says you won't sell any information to anybody ever, but you do sell information to people sometimes. Well, that's a problem for you. If the FTC decides to investigate and go after you, that's a problem. That's a violation of Section 5 of the FTC Act. It's a deceptive act or practice in or affecting commerce. And so that can be a real problem for you. Obviously, FTC is something that you don't want problems with. So, again, a really easy pitfall to avoid is have a privacy policy and have it actually reflect what your website does with information. So if you plan to sell or distribute users' emails or other information, say so. I mean, how many people really truly read privacy policies and then don't give their information if they really want whatever you have on your website? Not very many. But a lot of people think they should say what people want to hear, not what they do. You should reflect how you use information and what information you collect in your privacy policy. Explain what information is collected. Address links that you don't. If they click on a link on your website, you're not responsible for the privacy policy of that third-party website. Specify a way for users to contact you, and then consider disclosing how users can deactivate cookies in their browser. Oh, the last one's important. I see this all the time. Privacy policies that absolutely guarantee that your private information that you're giving them will never be hacked. No one's ever going to get it from us. You can't guarantee that. So why say that? And the problem is that if it does get hacked, and then the FTC starts paying attention to what did you do with that information? How much access did you give in your company to that information? There have been several lawsuits that the FTC has brought because people guaranteed things in their privacy policies about personal information, and then they just didn't take commercially reasonable steps. They didn't change access codes when people left the company and things like that. Just don't guarantee it. Just say that you're going to use commercially reasonable efforts to keep that protected. That's what you're going to do. So you might as well say it. Excuse me. Okay, next, FTC regulations and truth in advertising. Again, Section 5 of the FTC Act prohibits unfair, deceptive acts and practices in or affecting commerce. This has been around for a really long time, but the FTC comes out with new guidelines on how they're going to enforce it, how they're going to interpret this guideline. And they did, even last year, they came out with some new guidelines and regulations in order to try to protect against business opportunity. So, excuse me, what issues are they? Truthful versus false or misleading, substantiating claims with reasonable evidence, using clear and conspicuous disclaimers, and aiding by posting or abiding by posted privacy policies. Okay. So, business opportunity disclosures. Last year it went into effect. It was passed at the end of the year before, but the business opportunity rule, it reflects certain disclosures that have to be made if what you're offering is considered a business opportunity. And there's a very specific rule of business opportunity in these guidelines. Business opportunities include offers that provide a buyer with customers, accounts, or outlets, provide locations for displays, vending machines, equipment. Sometimes it's, envelope stuffing, things like that. Or if they buy back the merchandise that the buyer produces. So if it says that, you can work at home, and if you choose to get out of the business, then we'll buy back whatever inventory you have. So if whatever you're selling, let's say you're the publisher, and whatever ad you're running, the advertiser is selling a business opportunity that falls under this guideline. Well, what does that mean? Then the seller, the advertiser, must provide to customers a one-page disclosure document. The guidelines are very specific on what this entails. Excuse me. If the offer also makes an earnings claim, there's an additional disclosure statement. If you're the affiliate, if you're the publisher and you're running one of these, you want to make sure that the advertiser really does have a disclosure statement, and at least that they represent to you that they're going to send that out in compliance with the Act. You also want to make sure before you put any earnings claims out there that the advertiser has the required information in order to respond to an inquiry regarding that earning claim. And make sure that you don't contradict the information that's contained in those disclosure documents. So, one thing that you can get into a lot of trouble with is if that disclosure statement does say that, somebody's going to make $2,500 and you say that somebody could make up to $10,000 a week or whatever, you want to make sure that your claims are in line with whatever those disclosure claims are. Okay, consumer endorsements. What's a consumer endorsement? Consumer endorsement is when a consumer says that they really like a product, they bought something, maybe it's a blog. I really like this this product. In this instance, we're going to talk about, and we're going to talk about blogs in a minute. But in this instance, what we're going to talk about is somebody, maybe a testimonial, somebody saying, I lost 30 pounds using Weight Watchers, right? So does the ad feature a consumer explaining their own experience with the product? Is their experience common? Okay? I lost 30 pounds. That doesn't mean that you'll lose 30 pounds or you'll lose 30 pounds. Can the advertiser support the claim that everyone should expect those results? Excuse me. If not, then the advertisement has to clearly disclose the results that are generally expected. Now, a lot of you might have seen websites that say, the disclaimer is, results not common. That used to be a safe harbor. It's not anymore. Guidelines that were posted, I think it was last year, no longer allow that as a safe harbor. So this is an example of what sort of used to be acceptable, right? Everybody knows Jared. Jared lost lots of weight eating Subway and walking, right? Now, you'll see in Jenny Craig, the top says, I took control of my life by joining Jenny Craig and I lost 40 pounds. The bottom is what now is required, right? You can't just say at the bottom of that, results not common, and say 40 pounds. You now have to say, clients following the program on average lose 1 to 2 pounds, okay? So that's an easy way to trip up on FTC guidelines and be subject to claims by the FTC. You have to disclose connections between endorsers and sellers. So what does that mean? The buzzword is that you have to disclose a connection that might materially affect the weight or credibility of an endorsement. Okay? And we talked about how we were going to talk about maybe some blogs, right? Might be relevant to you. What do you need to pay attention to? Advertorials. Sometimes, a lot of people, for a while, were using a lot of advertorials. You can't mislead the consumer into thinking that it really is a legitimate news site if it's not. Okay? So the FTC will crack down on that. The FTC is cracking down on blogs that don't advertise or don't acknowledge that they're receiving monies for giving good reviews. Message boards, if you're, let's say, maybe you have employees going and stuffing message boards about the product of their employer without disclosing that they're employed by the advertiser. So here's some examples. A consumer buys dog food, blogs that their dog's coat's shinier. Is that considered an endorsement, or is that not an endorsement? Right, not an endorsement. Consumer receives free dog food from the pet store because they bought, 12 pounds in the last month, and so they get, some free dog food from the pet store. Then she blogs that dog food makes her dog's coat shinier. Is that an endorsement or not an endorsement? They got it free. It's not an endorsement because the free dog food came from the pet store, not from the advertiser, right? Now consumer joins a network marketing program, receives products, gets some free dog food, maybe gets paid to blog on it, maybe gets $500 to write a review. That is an endorsement that is a connection that needs to be disclosed. You received money to write that review, and the FTC views that as materially, that it would materially affect a user or consumer's value of that endorsement. So this talks about, again, bloggers are treated differently. A lot of times I hear people say, well, that doesn't happen when somebody sends that dog food to my local newspaper and they write a review on it. And for whatever reason, the FTC has determined that is different than a blogger, and they interpret those endorsement reviews or endorsement disclosure requirements differently. They feel that the consumer understands that a newspaper likely received free stuff to review it or got paid money or whatever, and so they don't feel that it's material. All right. Next issue is trademark infringement. What's a trademark? A trademark is, the protection of words, names, or symbols. Coca-Cola, example of a trademark. Prevents other parties from using confusingly similar marks. Lasts a long time if you do it properly. So what exposure do you have if you infringe on trademarks, right? Trademark owners can get actual damages, and they can get profits that are attributable to your infringement. They can get potentially attorney's fees. They can sue you in a foreign state, maybe a state that you don't do business in currently, but you're put on notice that since they filed a trademark and they protect that mark and they're located in that state, you can be drawn into litigation somewhere else. You can get an injunction against future use of the mark. So trademark registration is not mandatory, but it's helpful, right? Just because you could still just use a trademark that you like, use the name of your company, and not file it. We'd recommend that if you do use it, that you should protect yourself by filing with the USPTO office. You get the presumption of ownership in the mark, which is just a one issue you don't have to prove in an infringement case if you have a trademark that you're trying to enforce. Excuse me. Ability to bring suit in a federal court. So just like I said, you might make yourself suspect or subject to litigation if you infringe. If it's your mark, you can sue somebody in your home court instead of having to sue them potentially somewhere else. You can obtain registration in foreign countries once you've filed your mark. Two common types of online advertising where people might get into trouble with trademark infringement. Keyword advertisements, Google AdWords, and then just banner ads, right? So we'll talk about those. So when your advertisements utilize someone else's trademark, you can have potential liability. Well, the key question is whether your use of the trademark is likely to cause confusion. Now, a lot of you probably use AdWords. Maybe you bid on terms. Maybe you bid on a term that is a protected mark. Well, one of the big issues to avoid infringement, avoid liability, is just if you buy the AdWord, make sure you don't, of a trademark, make sure you don't use that trademark in the text of your AdWord advertisement. So you might buy the term, I don't know, say you buy Nissan, okay? You bid on it, you get it. Don't use the term Nissan in your explanation of where that link is going. You need to make sure that it's not confusing to the consumer that you're linking to something other than Nissan's website or something owned by Nissan. Make sure the ad's separated and labeled as an advertisement. You'll notice, Google used to say sponsored links. They now just say ads on them. So on the right-hand side or at the top. If you have a website where you have sponsored links or you use ads, you need to disclose that those are sponsored links or ads. Those banner ads or whatever. You have to identify the source of the advertisement. So again, that's the ad language. Thank you. You have to disclose on that website those sponsored links. Okay, copyright overview. Protects original works of authorship. So trademarks were names, right? Coca-Cola. This is photographs, could be videos, could be text. Could be an article on something. So you have the exclusive right to reproduce, distribute, or display the work that's yours, if it's your copyright. Okay? So just because it's on a website doesn't mean that it's fair game and you can use a picture just because it's up there. Again, I know nobody in this room would do that, but lots of people think that just because something's posted on a website, that it's fair game, they can use it in a banner ad or they can use it in whatever they want for their own business purposes. Just because it doesn't have one of those C's, the copyright symbol, doesn't mean that it's not copyrighted. Okay? Similar to trademark, you can protect copyrighted materials. You can protect your photograph by registering that and getting a copyright for it. And by doing that, again, that protects you similarly to the trademark, gives you the ability to bring suit, presumption of validity, that you own that picture, allows you to get attorney's fees if you bring suit against somebody for infringement. And then if you filed, you can also get you have the potential to get statutory damages. If you recall, we talked about for trademarks, you would have to prove actual damages. Here, if you've filed your copyright, you can get statutory damages, and depending upon the willfulness of the infringement, let's say the 750 might be, accidental use, whatever. The 150 is you face shop, took off the C, maybe you changed it a little bit to say something that was better for you, but you intended to modify that mark knowingly or that copyright. You can be subject to as much as $150,000 per infringement. So it's a big copyright infringement, especially willful copyright infringement that's registered. A registered copyright can be really expensive. Okay, we talked about DMCA, and I'm sort of running out of time, so I'm going to go quick on this, but we talked about DMCA before. If you have materials that you allow or content that you allow posted from third parties on your website, you really should register with the DMCA. So it helps with, it prohibits circumvention of technologies designed to protect copyright. It limits copyright infringement liability if you're a service provider, if you are allowing third-party content, you probably fall under the service provider definition, which is really pretty broad. It streamlines notice and takedown procedures, so you have to follow the DMCA requirements. If somebody gives you a takedown notice, you need to comply with those takedown notices in accordance with the DMCA. And like I said before, you need to have in your privacy and in your terms of service information, an email, snail mail. How does somebody get a takedown notice to you? It establishes a procedure for copyright owners to discover the identity of infringing internet. So this is just an example of a takedown. After somebody got a takedown notice from Microsoft, this is the impact that it had. And this just talks about the eligibility of DMCA. If you allow third-party content on your website to be posted on your website, whether that's comments or photos or anything in between, you really should make sure that you register. And this is a picture of this is how simple it is. This is a one-pager that you have to use to do DMCA, and you have to send it in, and I think it's $150 is my recollection. So what's the bottom line? Terms and conditions, make sure you have them. Don't use pictures without author's permission. Buy licenses of images. I mean, there's lots of places that you can buy for cheap. You can buy images if you need to use them, and register for the DMCA. This is just some examples of some places that you can get additional information. We also have that we give our clients just a reference material that's a 2-pager, sort of real brief summary of all of the acts that I described, as well as a few additional ones. Like I said, it's about a 2-page document. If anybody would like me to email that to you after this, feel free to come up and give me your card, and I'll email you a copy of that sort of reference material. And that looks like it's my time. So if anybody has any questions they want to ask, feel free to come up, and be happy to answer any questions. But I really appreciate all of you coming today. And hopefully I've given you a little bit more information than you had before you came in. Hopefully by using that information you can reduce some of your business risks a little bit more than you had this morning. So thank you.